Stop scrolling for a second. If you are married to a United States citizen, thinking about getting married, or already somewhere in the marriage-based green card process, there are changes you cannot afford to ignore. What used to work even a few years ago can now backfire badly, and many couples are finding out too late after delays, denials, or interviews that feel more like interrogations. What I am about to explain can realistically determine whether your case moves forward smoothly or turns into a long, stressful nightmare. I have spent years breaking down immigration rules in plain English, watching patterns and approvals and denials, and helping people understand what officers actually look for behind the scenes. This is not hype. This affects real families, real marriages, and real futures. Marriage-based green cards have always been closely examined, but enforcement priorities have shifted in a way that makes this path far less forgiving than it used to be. If you are at the beginning, in the middle, waiting for an interview, or even holding a conditional green card already, you need to understand how the landscape has changed and how to protect yourself. Many people assume that being legally married is enough. It is not. That misunderstanding alone has cost couples years of their lives. Before we go deeper, let us make sure we are on the same page about what a marriage-based green card actually is and how the process normally works. When a United States citizen or lawful permanent resident marries a foreign national, they can sponsor that spouse for permanent residence. Permanent residence is what people commonly call a green card. It allows the foreign spouse to live and work in the United States on a long-term basis. However, the type of green card you get at first depends on how long you have been married. When the case is approved, if the marriage is less than 2 years old at the time of approval, the government issues a conditional green card that is valid for 2 years. It is not permanent yet. Near the end of those 2 years, both spouses must file another petition to prove the marriage is still real and ongoing. If the marriage has already passed the 2-year mark when the case is approved, the foreign spouse usually receives a 10-year green card right away. The process itself involves several stages and different forms, depending on where the foreign spouse is living. Typically, the citizen or permanent resident spouse starts by filing a petition to prove that a valid qualifying relationship exists. If the foreign spouse is already inside the United States and eligible, they may be able to apply for permanent residence without leaving the country. If the foreign spouse is outside the United States, the case goes through a United States embassy or consulate abroad. Both paths involve background checks, medical exams, document reviews, and interviews. On paper, this process looks straightforward. In reality, it has become far more demanding. The biggest shift you need to understand is the level of scrutiny. Authorities have placed a renewed focus on detecting fraud, especially in marriage cases. Fraud does happen. Some people marry only to obtain immigration benefits with no real intent to build a life together. Because of that history, officers are now trained to assume nothing and verify everything. Genuine couples feel this pressure the most because they are often unprepared for how personal and detailed the process has become. One of the most noticeable changes is the interview. Interviews are now expected in nearly every marriage-based case. Years ago, some couples were approved without ever sitting down with an officer. That is no longer something you should expect. And these interviews are not casual conversations. They are structured, detailed, and designed to uncover inconsistencies. In many cases, spouses are questioned separately, and their answers are compared. You might be asked things that feel intrusive or even ridiculous. How you met, who made the first move, what your first date was like, where you live, and how your home is laid out, which side of the bed each of you sleeps on, what time your spouse usually leaves for work, what you did together last weekend, which family you spent the last holiday with, even small details like favorite foods or daily routines. The goal is not to embarrass you. The goal is to see whether your answers reflect shared lived experience or vague guesswork. This is where many real couples get nervous and stumble, not because they are lying, but because they underestimate how closely their answers are compared. A small inconsistency does not automatically mean denial, but patterns of mismatched answers raise concerns. Officers are not expecting perfection, but they are looking for natural alignment that comes from actually living together. Another major change is the increase in requests for additional evidence. These are formal notices asking you to submit more proof. They slow your case down and put pressure on you to respond correctly within a strict deadline. Ignoring or mishandling such a request can lead to a denial even if your marriage is real. What has changed is how often these requests are being issued and how detailed they have become. The standard for proving a real marriage is now much higher than simply showing a marriage certificate. Officers want to see that your lives are genuinely intertwined. They look for proof that you live together, share financial responsibilities, plan a future together, and are recognized as a couple by friends and family. This usually includes joint financial records, shared housing documents, insurance policies, tax filings, photographs over time, travel records, and statements from people who know you as a couple. Here's the part many people do not like to hear. Not all evidence carries the same weight. A stack of posed photos taken on the same day is not as convincing as years of everyday documentation. A joint account that was opened last week but barely used raises questions. Officers are trained to spot evidence that looks created for immigration purposes rather than naturally accumulated through daily life. On top of that, officers actively look for what they call red flags. These are factors that statistically appear more often in fraudulent cases. Examples include large age differences, very short relationships before marriage, big differences in education or financial background, lack of a common language, or marriages that happen right after a visa problem or immigration violation. None of these automatically disqualify you. Plenty of genuine couples fit one or more of these categories, but if they apply to you, your case will likely receive extra attention, and you will need stronger evidence to offset those concerns. Now, let us talk honestly about consequences, because this is where people often underestimate the risk. If an officer determines that a marriage is fraudulent, the case is denied. That alone is devastating. But it does not stop there. Marriage fraud is treated as a serious federal offense. It can lead to permanent bars from future immigration benefits, removal proceedings for the foreign spouse, and potential criminal charges for both parties. In extreme cases, investigations can extend beyond paperwork. Authorities may conduct unannounced home visits to verify that spouses actually live together. They may look for personal belongings, shared spaces, and signs of a real household. For couples with a conditional green card, the pressure does not end after approval. Removing conditions has become one of the most challenging stages. Processing times are long, interviews are more common, and requests for additional evidence are frequent. Couples must prove not only that the marriage started in good faith, but that it continues to be genuine. Divorce or separation during this period complicates everything, although there are exceptions in cases of abuse or hardship. This brings up an important and often misunderstood protection. If a sponsored spouse experiences abuse, there are legal pathways that allow them to seek status independently. These protections apply regardless of gender and are designed to prevent people from being trapped in dangerous situations due to immigration dependency. It is critical for anyone in that situation to seek proper guidance because these cases are handled differently and require careful documentation. Different entry scenarios also matter more than people realize. For example, couples who plan to marry after entering on a fiancé visa face stricter review than in the past. Similarly, people who enter the United States on a temporary visa and later marry must be prepared to explain their original intent. Marrying after entry is not automatically illegal, but if officers believe there was a pre-planned intent to immigrate permanently using a temporary visa, they may consider that a misrepresentation. Consular processing carries its own risks. While it can sometimes move faster, it also triggers bars for unlawful presence in certain cases. Spending too much time in the United States without proper status and then leaving can result in multi-year bans from re-entry. Waivers exist, but they are difficult to obtain and require proving serious hardship to the citizen or permanent resident spouse. Let me share a realistic example to bring this home. Imagine a couple who met online, spent several months talking, then married during a short visit. They are genuinely in love, but most of their relationship has been long distance. When they apply, they submit wedding photos, chat screenshots, and a few travel records. They assume that is enough. At the interview, they are separated and asked detailed questions about daily routines they have never actually shared yet. The officer issues a request for more evidence and schedules a second interview. Months turn into a year. Stress builds. The relationship is tested. This scenario plays out far more often than people admit. It does not mean the couple will fail, but it means preparation matters far earlier than most expect. So what can you do right now to protect yourself? First, document your relationship from the beginning in a natural way. Take photos during ordinary moments, not just special events. Save communication records if you are apart. Keep proof of visits, shared plans, and joint decisions. Second, be completely honest in every form and every interview. Trying to hide something usually causes more damage than the truth. Officers are trained to notice inconsistencies, and once credibility is questioned, everything becomes harder. Third, prepare for interviews thoughtfully. Review what you submitted. Make sure both spouses are familiar with the information. Talk through your shared history so that answers come naturally, not rehearsed. Fourth, take requests for additional evidence seriously and respond thoroughly and on time. Use them as an opportunity to strengthen your case rather than panic. Fifth, continue building evidence throughout the process. This is not a one-time submission. Immigration timelines are long, and officers expect to see that your marriage grows and evolves over time. Sixth, understand the financial sponsorship requirement. The sponsoring spouse must generally show the ability to support the immigrant spouse. This does not mean being wealthy, but it does require meeting certain income guidelines or using a joint sponsor if necessary. Seventh, recognize when professional help may be worth it. Immigration law is unforgiving. Small mistakes can have lasting consequences. While not every case requires an attorney, cases with complications, red flags, or past immigration issues often benefit from experienced guidance. There are also common mistakes worth avoiding. Submitting the bare minimum, giving inconsistent answers, living separately without clear explanation, underestimating the interview, assuming that love alone is enough without proof. These errors are avoidable with awareness and planning. Same-sex marriages are recognized for immigration purposes, and they follow the same standards and scrutiny as any other marriage. Age differences, cultural differences, or online relationships are not disqualifiers, but they do require stronger documentation and clearer explanations. Processing times have increased across the board. Adjusting status inside the United States often takes well over a year. Removing conditions can take even longer. Patience is part of the process, but preparation determines whether that waiting period is merely inconvenient or deeply stressful. Let me give you one more example. This time, near the end of the journey, a couple receives a conditional green card and assumes the hardest part is over. They stop keeping records, close joint accounts, and focus on life. 2 years later, when it is time to remove conditions, they scramble to reconstruct evidence they no longer have. Interviews are scheduled. Questions are tough. The case drags on for years. The lesson is simple but uncomfortable. Immigration looks backward. It judges the entire history of your relationship, not just your intentions at the start. To wrap this up clearly, the marriage-based green card process is still a valid and widely used path, but it demands more care than ever. Genuine couples succeed every day, but success today depends on preparation, honesty, and understanding how officers think. If you treat this like paperwork, you are taking a risk. If you treat it like a long-term documentation of your shared life, you give yourself the best possible chance. If this helped you see the process more clearly, take a moment to support the channel so you do not miss future updates. Share this with someone who is starting or struggling with their case. Leave a comment if you want a specific topic covered next, or if you have a general question. Immigration rules change, but informed decisions always matter. Stay prepared, stay honest, and I will see you in the next